me speak from this podium here. Let me just, on behalf of President Barbara Snyder, let me welcome everybody. I'm Bud Bazelak, the provost, to this event this afternoon, the annual Constitution Day Forum. It's great to be here. This is an event I've actually been involved in a couple other times in the past, and it always leads to some very interesting conversation, discussion around very complex issues certainly related to the Constitution. I want to thank Professors Lund and Rosenthal for being here today, making the trip to join us, and I'm sure they're going to provide some stimulating conversation, as will the student group. I want to thank Andrew and his student members of the committee for your leadership in putting this together. I want to thank the faculty advisors and certainly the different organizations for working together to put together today's program on triggering the Second Amendment in terms of related to constitutionality of gun rights and gun control. Although I'm a material scientist and engineering professor, I do watch PBS, and so I actually do watch the Constitution show periodically. And you know, when you watch that, it really is really pretty clear, even to a metallurgist as I am, that the Constitution issues are as relevant today as they were at the creation of the document, and certainly in many cases even more so. Many issues that we deal with and often are topics of conversation and exploration on that program, literally relate to issues around every amendment. You can talk about the Second Amendment today, but you could go down the list in terms of issues that relate to privacy, certainly very important today. Issues that relate to freedom of speech in terms of some of the different activities that we've had going on around the country in recent years related to that. So you could, again, talk for hours about these different issues, and I'm sure we got a great conversation today. As a technologist, one of the interesting aspects that is certainly stimulating and complicating many of these conversations relates to just the use of technology. Something as simple as the internet around privacy issues. And so I'm not sure that's going to come up much today in our conversation, but it's certainly, from my perspective as an engineer and a scientist, something that when I watch that show, for example, and deal with the constitutional issues, the Bill of Rights issues, and how those are interpreted, and all the challenges that we face, the technology piece is one that I think is going to create the content for many more meetings like this and many more discussions going forward into the future. So thanks everybody for being here today. I know we have a short time frame to work in, and so I'm going to just again welcome everybody and thank you. Bye-bye.
Thank you, Provost Bazelak. Good afternoon, ladies and gentlemen. My name is Kylie Condon, and I'm the Mistress of Ceremonies. Distinguished guests, faculty, students, and friends, the purpose of today's forum is to celebrate the 226th anniversary of our founding charter, the Constitution. It is an honor to welcome Professor Nelson Lund of George Mason University and Professor Lawrence Rosenthal of Chapman University. Professors, the Constitution Day Student Committee sincerely appreciates your taking the time to be here today to discuss the constitutionality of gun rights and regulations and to answer our questions. I would like to introduce our three panelists for today, Philip Hoffert, Krithika Rajkumar, and Elizabeth Vitale, as well as our moderator, Andrew Breland.
Thank you, Ms. Condon. This morning, gunfire broke out in the Washington Navy Yard in Washington, D.C. At least 12 people are dead, and one shooter remains on the loose after gunmen opened fire dressed in military-style uniforms within the naval complex. Throughout the event today, I ask that you keep in mind that the issues we're talking about have real-world consequences, and that no matter what your opinion is on these issues, we can't stand for these violations of our most basic right of security. Ladies and gentlemen, the Second Amendment of the U.S. Constitution reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." In 2008, in D.C. v. Heller, the U.S. Supreme Court held that the Second Amendment guaranteed an individual right to bear arms. In 2010, in McDonald v. Chicago, the court applied this right to the entire country. However, the right to bear arms is not absolute. Like the rest of the Bill of Rights, it's subject to reasonable restrictions. Federal and state legislatures have attempted to limit gun rights accordingly. Recent mass shootings in Aurora, Colorado, Tucson, Arizona, and Newtown, Connecticut have led to calls for bans on assault weapons, increased background checks for those purchasing them, and the formation of a commission to study the effects of gun violence in America. A bill in the Senate addressing these points, the Public Safety and Second Amendment Rights Protection Act, failed by 6 votes this April. Other limits on the right to bear arms have met similar fates, including Maryland's requirement that residents show good and substantial reason to own a gun, ruled unconstitutional in March 2012 by Maryland's highest court. Additionally, Illinois' ban on concealed carry weapons was ruled unconstitutional in December by that state's highest court. And just last week, 2 legislators were removed from office after a recall election due to their support of gun regulations. It is clear that the nation continues to question what, if any, laws concerning gun rights are constitutional, and specifically which rights are guaranteed by the Second Amendment. Today, Professors Lund and Rosenthal will examine constitutional guarantees and restrictions. They will respond to questions about recent shootings and legislative pushes for limits on the right to bear arms. These are indeed controversial issues. And out of respect for the speakers, we ask that you please silence all cell phones and remain courteous throughout the program. Following opening statements, each speaker will respond to questions, with 5 minutes allotted per response. Each question will be directed at either Professor Rosenthal or Lund, and the other will have a chance to make a rebuttal for 3 minutes. We will return to the original speaker for a final 2-minute response to every question. Closing statements of 5 minutes will conclude the program. Professor Lund, the floor is yours. You have 10 minutes, and so will Professor Rosenthal.
Until fairly recently, the Second Amendment was considered to be a kind of joke by the courts and by the American legal establishment. As you know, that changed in 2008 in the Heller case when the Supreme Court struck down the handgun ban in the District of Columbia. This was the first time in history that any federal court had declared any law unconstitutional under the Second Amendment. Justice Scalia wrote the opinion in Heller, and it has many, many serious problems. I won't even be able to scratch the surface of the problems in Justice Scalia's opinion. But he did reach 2 important conclusions, both of which are correct, about the original meaning of the Second Amendment. First, the right to keep and bear arms is a private right of individual citizens, not a right of the states to organize the National Guard or state militias. Second, the purpose of the Second Amendment is to protect the natural or inherent right of self-defense, including the right to defend yourself against criminals. Unfortunately, this does not get you very far in evaluating the constitutionality of specific gun control regulations. Why? Because the historical record contains virtually no discussion about the scope of the Second Amendment right. Very little discussion, virtually none, about the scope of the right to keep and bear arms. And that's what you need to know in order to decide specific questions about specific regulations. Now, that problem becomes quite clear in the Heller opinion itself when Scalia addresses the question of whether the handgun ban violates the Second Amendment. And he decides, he and a majority of the court decided that it did, but why? The only reason he gives is that handguns are a popular weapon of self-defense for self-defense today. No discussion of any history, nothing about the original meaning of the Second Amendment, just a kind of statement that, well, they're really popular today, and therefore it's unconstitutional to ban them. The rest of the opinion consists, in my view, of an incoherent set of comments that provide very little guidance about how to analyze other gun control regulations. Okay, we've been told by the Supreme Court a handgun ban is unconstitutional. What about all kinds of other things? Very little guidance is provided by the court's opinion. Surprisingly, perhaps, the Federal Circuit courts, that's the Court of Appeals, have largely coalesced around an analytical framework that can be roughly summarized as follows. First, some regulations, primarily those that are long-standing, are presumed not to infringe the right protected by the Second Amendment. Second, regulations that severely restrict the core right of self-defense are subject to what's called strict scrutiny. Now, that's a legal test requiring the government to prove that it is using the narrowest possible means to accomplish a compelling government interest, and very few laws of any kind will pass that test. Third, regulations that do not severely restrict the core right are subject to what's called intermediate scrutiny. Now, that's a more relaxed legal test that requires the government to prove that the law is substantially related to an important governmental objective. This kind of tiers of scrutiny approach is used in other areas of constitutional law, so it's not surprising that the lower courts would try to adapt it to this area. But it was conspicuously not adopted in the Heller opinion. And that problem generated an interesting debate in the Federal Court of Appeals for the District of Columbia Circuit, which I'm going to just very briefly describe. After losing the Heller case, the D.C. government adopted a new gun control law. And in a case called Heller 2, the named plaintiff in the earlier case, along with several other individuals, challenged several of its provisions. And I'm just going to focus on two of them because they've been subject to a lot of commentary recently. First, a prohibition on so-called semi-automatic assault rifles, and second, a ban on any magazine with a capacity of more than 10 rounds. The Heller 2 majority concluded that it's reasonably certain that the bans do not substantially burden the Second Amendment right, and then following this tiers of scrutiny approach, the court then applied intermediate scrutiny and upheld both regulations. In dissent, Judge Brett Kavanaugh argued that the majority's approach to the case was based on a complete misinterpretation of Heller. In his view, the Supreme Court has rejected the tiers of scrutiny approach. Instead, according to him, Heller teaches that courts are to assess gun regulations by looking to history and tradition and by drawing analogies from these sources when dealing with modern weapons and new circumstances. Anything else, he maintains, involves judicial interest balancing, which Heller expressly condemned. Now, in my view, Justice Scalia's opinion in Heller is so confusing that there's no way to tell for sure which approach is the right interpretation of the case. But I think it's pretty clear that the majority's analytical approach is workable and Judge Kavanaugh's is not. And judging from the sign back there, it doesn't look as though I'm going to have time to get into too much detail about Judge Kavanaugh's position. So I'll just make this conclusory remark that I think I can show that it's not workable and turn to the majority opinion. The basic problem with Kavanaugh's approach is that the history and tradition aspects of Scalia's Heller opinion are kind of, I don't want to say dishonest, but I do want to say very misleading about what they can and cannot do. So I think the majority's analytical approach in Heller 2 is something like it is the only workable approach. But that does not mean that I think the majority correctly decided the case, and that's what I want to focus a couple minutes on. The challenged regulations that I mentioned were manifestly meant to suppress the legitimate exercise of constitutional rights, and the majority was far too deferential to the government in reviewing them. Let me start with the ban on certain semi-automatic weapons. First, the banned rifles are defined primarily in terms of cosmetic features, and they're indistinguishable functionally from other semi-automatic rifles that are not banned. The regulation is therefore arbitrary and without any real relation to public safety, and it fails the majority's own intermediate scrutiny test. There's more I could say about that, but I'm going to suppress it because of lack of time. What about the ban on high-capacity magazines? The majority offered two justifications. First, it said that such magazines give an advantage to mass shooters. Maybe so. But how could the district's regulation possibly reduce that problem? Large-capacity magazines are freely available by mail order and at stores in nearby Virginia. The court seems to be assuming that criminals bent on mass shootings will refrain from obtaining such magazines out of respect for DC's regulation. Now, rather than thoughtlessly accept this really preposterous assumption, I think the court might well have taken judicial notice of the opposite. The majority also said that large capacity magazines can tempt legitimate self-defense shooters to fire more rounds than necessary. Once again, maybe so. But that shows at most that banning such magazines could conceivably have some good effects on some occasions. But exactly the same thing could be said of DC's original and unconstitutional ban on all handguns, which illustrates why the argument has to be fatally flawed. Just think about an analogous case under the First Amendment. Banning medical books containing photos of corpses or cadavers might save some children from psychological trauma if they came across such books. That would be a good thing too, but nobody would consider such a book ban constitutional. Assuming that intermediate scrutiny is appropriate, the government is required at a minimum to show a substantial relation between the regulation and public safety. The Heller majority cited no evidence showing that the magazine ban would save any significant number of lives or any lives at all, nor did it even consider the possibility that innocent civilians might lose their lives because they ran out of ammunition while trying to defend themselves. Now, where does that leave us? I think it leaves us with what I regard as almost inevitable conclusion that the courts are going to apply some kind of means-end scrutiny, whether they call it tiers of scrutiny or not. And that what's really going to determine the future of Second Amendment rights is how valuable judges think the Second Amendment is. Judges think the First Amendment rights are very valuable, and we have a long and complex tradition of rigorous judicial scrutiny of laws that violate the right of free speech. There are some judges willing to use similar rigor in analyzing Second Amendment cases. Unfortunately, there aren't enough of such judges yet, but there are some. They don't seem to be on the DC circuit, however. Thank you.
Professor Rosenthal.
Thank you. I want to start with Antonin Scalia, pretty much the place Professor Lund started. Justice Scalia, as the law students in the room knows, is the great foe of common law methods for interpreting the Constitution, because that, he says, gives rise to this odious thing called a living Constitution, made by judges, not by the framers of the Constitution. He tells us that the Constitution, like any other legal text, has to be written in light of its meaning at the time of adoption, the original meaning of the words. And in District of Columbia versus Heller, the case establishing that the Second Amendment grants an individual right to keep and bear arms, Justice Scalia was able to utilize that methodology. Through his assessment of the historical evidence, Justice Scalia gives us what he determines or concludes is the original meaning of the Second Amendment. In short, he tells us that the right of the people in the operative clause of the Second Amendment means an individual right. The word keep means to possess firearms. The right to bear means the right to carry in case of confrontation. And arms, what are they? They're any firearm in common civilian use. So, if all you're doing is using the original meaning of the operative clause, we have an enormously robust right. Every individual has the right not only to possess, but to carry, in case of confrontation, any firearm in common civilian use. Yet, as Professor Lund suggests, a lot of puzzles are left by the Heller opinion, and I want to focus on a couple of them right now. The first puzzle is the dicta that Justice Scalia gives us on what he talks about as presumptively lawful firearms regulation. And he gives us examples. He says in the opinion, these aren't exhaustive, but here are some examples. And he says prohibitions on the possession of firearms by convicted felons, the mentally ill, are examples, as are prohibitions on carrying concealed firearms or carrying firearms in sensitive places. Now, I say that's a puzzle because if the operative clause, in particular the original meaning of the operative clause, is what we need to worry about, how can you prohibit firearms under these circumstances? Professor Lund uses the analogy of the First Amendment. Well, you can't prohibit convicted felons from exercising the right of free speech, or perhaps more pertinently, since the Supreme Court's decision in Neer versus Minnesota, the fact that you abused your free speech rights by publishing a defamatory newspaper doesn't mean that publication can be enjoined. There's no death penalty for the First Amendment, but how can a felony conviction be the death penalty for Second Amendment rights? Same thing with the mentally ill and these other prohibitions. Now, you could say it's only dicta, it's not the precise holding of the court. Justice Scalia does say, well, we'll deal with these things in subsequent cases, so maybe that's not as troublesome as it first appears. But what about the holding? If there's an individual right to keep and carry any firearm in common civilian use, then this is a slam dunk case. You can't ban handguns, you can't ban anything as long as it's in common use. But that's not what Justice Scalia tells us, as Professor Lund indicates. Instead, he throws a ton of words at us that amount to saying, well, the Second Amendment is about a core right of lawful armed defense, especially in the home. And this law strikes at the heart of that core right. Now, where's that coming from, this notion of a core right and the extent to which it's burdened by a challenge regulation? Not from the original meaning of the operative clause. What's going on? And then we look at what the lower courts have done since Heller, and as Professor Lund indicates, the original meaning of the operative clause has played almost no role in the litigation in the lower courts. A couple weeks ago at the meeting of the American Political Science Association, I was on a panel with somebody from the NRA, which called the pattern of decisions in the lower courts since Heller a campaign of massive resistance. His words, not mine. But it's right. Instead of focusing on what Justice Scalia tells us is the original meaning of the operative clause, the courts tend to use a kind of means-ends scrutiny in light of the burden imposed by the challenge regulation. Does it have sufficient offsetting benefits? Where does that come from? Certainly not the original meaning of the operative clause. This is a great puzzle. Are we seeing a campaign of massive resistance, or is something else going on? Well, if we then look at history, as Justice Scalia says we should, we find another puzzle, because historically, we have a long tradition in this country of regulating, even imposing prohibitions when it comes to the right to possess and carry in case of confrontation. The English Bill of Rights, which Justice Scalia tells us was the origin of our Second Amendment, it provided that Protestants could keep and bear arms as provided by law, suitable for their condition. So Catholics, no, you're out of luck. Women, I don't even want to begin with women. That wasn't even on the radar screen. And even then, Parliament could regulate, and only suitable, you could only have suitable arms. So Parliament could deal with the lower classes in the framing era. The right to bear arms was denied for suspect groups like, again, women, freed blacks, not to mention, of course, even slaves weren't on the radar screen. Some states denied the right to people who wouldn't swear loyalty oaths, and some states denied the right to Catholics. People had to produce their firearms under the militia laws at periodic musters where they'd be registered and inspected. What's going on there if you have this unfettered right? In the 19th century, more laws emerge. In the 1820s, the southern states start passing laws prohibiting the carrying of concealed weapons. In the north, more sweeping prohibitions on carrying in public places are enacted. After the Civil War, the same Congress that ratified the 14th Amendment passed a law prohibiting the arming of southern militias because these incipient Ku Klux Klan type groups were on a campaign of terror. Frontier towns often prohibited the carrying of firearms to stem epidemics of violence. And in the 20th century, of course, we see more laws, like the laws prohibiting possession by convicted felons or people to be adjudicated mentally ill. So what's happening? Well, my suggestion is that actually the problem is not that we're all ignoring the operative clause, but that it's too easy to overlook the preamble, a well-regulated militia. The only provision of the Bill of Rights that contemplates regulation is the Second Amendment. Now, Heller tells us something else awfully interesting about the original meaning of the Second Amendment. He tells us the original meaning of that word militia was not being in some sort of formal paramilitary organization. The original meaning was that the militia was everybody qualified to own a firearm. You were automatically in the militia. You didn't sign up. That group was well regulated. Now, if we take that seriously, then the Second Amendment contains textual acknowledgement of both firearms rights and regulatory authority in a way you see nowhere else in the Bill of Rights. And this is why courts, I think, have been looking to the tools they use in other areas of constitutional law where the Constitution recognizes both an individual right and legitimate regulatory power. Why what seems to be emerging, even implicit in Heller itself, is some version of an undue burden test, evaluating the extent to which challenge regulation burdens Second Amendment rights, and then assessing its justification. And that regulatory power is so broad that classes of individuals thought to be high risk, whether it was people who wouldn't sign loyalty oaths in the framing era or convicted felons today, can be denied those rights because we have this unusual textual recognition of regulatory authority. Now, I think Professor Lund is quite right. It all matters how you administer this test. And so I want to conclude with one of his examples about detachable cartridge and large capacity cartridges. And Professor Lund tells us, well, why would you make those illegal? Because criminals can still get their hands on them. Some of you laugh. Well, I have another thing that's funny. Why ban heroin? Criminals can get their hands on heroin. Nobody thinks that by making it illegal to possess heroin, we've wiped out heroin. In fact, most of the criminal law involves prohibitions that criminals can find their way around if they're determined enough to do so. So why do we ban heroin? And economists can tell us because when you make something illegal, it becomes more risky to engage in that behavior, the cost of that behavior increases, and we have less of that behavior. And the real test is going to be whether we analyze firearms regulation the way we analyze any other kind of regulation, that we want to affect the costs and benefits of undesirable behavior or not. And that will be how the gun control debate plays out when it comes to the Second Amendment. Thank you.
We'll now begin questions from the panel. The first question comes from Mr. Philip Hoffert.
Professor Lund, proponents of expansive firearms rights argue that the Second Amendment serves as a check on an overreaching government, just as proponents of expansive speech rights argue that the First Amendment can serve as a check on abuses of governmental power. How persuasive is the analogy between the First and Second Amendments as checks on governmental abuse?
Okay, that's a fairly long story, and I'm going to try to give a summary of it. But I want to start by saying I used an analogy to the First Amendment in my opening comments, and I think there are many ways in which the First Amendment is analogous to the Second Amendment, and that analogies from the First Amendment often could be appropriately used by the courts. That does not mean you can simply mechanically transfer one thing from the First Amendment area over into the Second Amendment area, because there are a lot of relevant differences as well. Now, the reason for adopting the Second Amendment is the reasons that the nation adopted the Second Amendment is a somewhat complicated story, but let me briefly summarize it as follows. At the Constitutional Convention, the delegates faced a conundrum. They were worried that the new federal government needed a lot more military power than had been given to the federal government, the national government, under the Articles of Confederation. But they were also worried that if you gave this brand new government, which was very much more powerful in many other ways, such as the new power to tax and so on, and gave it all this military power, it would become dangerous to liberty. It could potentially become tyrannical. So there was this conundrum. How do you protect national security with a strong federal military power without threatening our liberties, because that same power could be used against them? They resolved that debate at the convention in favor of giving the federal government almost unfettered military power. And the anti-federalists, the people who were opposed to the adoption of the Constitution, were extremely exercised about this, extremely exercised about it. And it was a big part of the debates in the ratification process. When they came time to draft the Bill of Rights, Madison and the other delegates responsible in the first Congress for it did not want to diminish the federal government's power. And yet, there were all kinds of things they were willing to do in the Bill of Rights, but they did not want to diminish the federal government's power. And so they drafted the Second Amendment in this kind of strange way that, in fact, did not diminish the federal government's power, but kind of gave a kind of lip service to the whole idea that we shouldn't give the federal government all this military power because we have these militias, these state-based militias. Now, I can go through the rest of the textual arguments about the meaning of the prefatory clause, but the outcome of that is the following. When the Second Amendment was adopted, what people were thinking about primarily was the danger of government oppression and the usefulness of privately held arms in resisting oppression. It was a perfectly reasonable concern at the time. Nobody knew how this new federal government was going to behave. It was not limited to that. It was not limited to that. It also included, as the operative clause by its language clearly signals, a desire to make sure that the people were able to protect themselves, not just from the possibly dangerous new federal government, but from being disarmed and thereby left vulnerable to threats against which the federal government could not or would not protect them. Now, in the more than 200 years since the adoption of the Second Amendment, the perceived threat of federal oppression, federal tyranny, has diminished quite a lot. That's what was in the minds of the framers primarily, and that has diminished a lot. But the other purpose of the Second Amendment has not diminished. It has not diminished. And while it's true that today at the margins, an armed citizenry is something of a deterrent against governmental oppression because it raises the costs of oppression to the government, the potential costs and thereby the risks, it is certainly the case that it is not realistic today to believe what plenty of people did believe in 1791, namely that if the federal government tried to conquer the armed populace of the United States, it would fail. That was a perfectly reasonable thing to believe in 1791, or oppress the people. They could fight back. That is a much less realistic thing today. But it does not mean that there's no marginal effect of the Second Amendment on government oppression, but by far the bigger realistic accomplishments that are possible under the Second Amendment today are enabling us to protect ourselves against threats that the government cannot or will not protect us against, primarily criminals. Thank you.
Professor Rosenthal, 3 minutes for rebuttal.
My own view is that the history is very complicated. Whenever I talk to law professors, I generally get a very clear, cogent statement about what the original meaning, what the framers' intentions were about the Second Amendment or anything. Whenever I talk to historians, I always get a different view. It's complicated, the data is noisy, and the historians have taught me to be cautious about the history. So rather than going into the complicated question of did Heller even get the history right, I'm going to take Heller as given, and then I'm going to agree with much of what Professor Lund just said, which is Heller tells us that whatever may have been the case in 1791, today, the Second Amendment is not very useful in resisting tyranny. When you've got a central army that's got helicopters and bombs and bazookas, this Second Amendment right really doesn't have much purchase. In fact, the 14th Amendment, ratified in 1868, and the vehicle by which the Second Amendment is applicable to state and local laws, one thing we can be pretty confident about is when they ratified the 14th Amendment, they weren't trying to secure a right to resist the federal government with force of arms. Resisting the federal government with force of arms, its poll numbers were falling in 1868. So the individual right that Heller tells us exists, Heller tells us has a discrete instrumental objective. It's designed to secure the right of lawful armed defense. Now that's precisely why, and I've got a paper I'm writing right now that focuses on this. I think the analogy between the First and Second Amendment, whatever its superficial appeal, is really quite misleading, because we have a discrete objective underlying this individual Second Amendment right, lawful armed self-defense. And once you focus on that, you realize why you need a lot of prophylactic regulation for the people who are more likely not carrying arms for purposes of lawful armed self-defense. But the First Amendment does not have this discrete instrumental objective in mind. The Supreme Court's rejected every effort to limit First Amendment protection to a single discrete instrumental objective. In fact, they tell us you don't even need any coherent message to get First Amendment protection. Abstract art is protected by the First Amendment because any form of expression is protected merely because it's expressive without any other instrumental objective in mind. That's going to give you one set of doctrine. But when you've got a text that acknowledges regulatory power and that has only a single discrete instrumental objective, lawful armed self-defense in mind, the doctrine ought to look very different. And that's why I think this effort to analogize between the First and Second Amendment is very wrong-headed, whether you'll look in terms of convicted felons or any other of the aspects of history regulation. I think the more you focus on the analogy, the weaker the analogy becomes.
Professor Lund, 2 minutes for a final response.
Let me take this opportunity to expand a little bit on the ways in which the First Amendment and the Second Amendment are and are not analogous. Textually, they're pretty analogous if you think about it. They both assert and protect a broad and fairly vaguely defined right. Both of them lack a lot of history indicating just exactly how broad the scope is, what exceptions there would be. And as a result, in both cases, I think the courts should, as they have in the First Amendment, go back to the original meaning of the constitutional provision in the following sense. The original meaning includes the text, which tells us some things, but doesn't tell us a lot of what we want to know, and the purpose. And in the First Amendment area, the court has done a pretty good job. I disagree with lots of the decisions, but on the whole, it's done a pretty good job of not letting the government get away with saying, well, we think it's a good idea and therefore it's constitutional. They've examined laws enacted by the governments in an effort to see whether they are inconsistent with the purpose of the free, well, I'm talking only about the free speech clause now, with the purpose of the free speech clause. And that's led to a lot of complicated doctrine and some decisions which are right and some which are undoubtedly wrong, either by being overprotective of the right or underprotective. You can do the same thing in the Second Amendment context. And the way to do that is to recognize that the original meaning includes not only the text, which doesn't tell us very much that's useful in terms of deciding cases, but also the purpose. And the focus on the original purpose of the Second Amendment leads you inevitably, I believe, to conduct some kind of means-end analysis in evaluating challenged regulations, just as it has in the First Amendment area. And the attitude with which judges conduct that means-end analysis is, I think, going to be what's going to turn out to be crucial on whether the Second Amendment just becomes kind of a joke in the sense that they say it's there, but it doesn't protect very much, or whether it will become more like the First Amendment, where the courts do a serious job of trying to protect an important constitutional right.
The next question comes from Krithika Rajkumar.
Professor Rosenthal, to what extent is international law relevant in deciding the scope of the Second Amendment?
I'm tempted to say none and sit down, but you probably wouldn't like that. And I am a law professor, so I'm not allowed. I'd lose my tenure if I just said none and sit down. So I'll say this: I stand with Justice Scalia on international law as a general matter. We're construing the United States Constitution, and that's all we should be worried about, period. Nevertheless, Justice Scalia tells me in Heller I need to worry about international law a little bit, because Justice Scalia tells us that we've inherited this Second Amendment right from the English Bill of Rights, that what the Second Amendment did was codify a pre-existing right, and as I've tried to explain, that pre-existing right from English law tolerated quite a bit of regulation. Now again, to go back to the analogy of the First Amendment, if Professor Lund knows what the original meaning of the First Amendment free speech clause is and what purpose they had in mind, my hat's off to him. I wrote a whole law review article on it, and I don't have the vaguest idea. And I don't think they did too. But if we're going to take originalism seriously, they permitted a ton of regulation of free speech back in 1791, kind of regulation today we never tolerate. They used what's called a bad tendency test in 1791, which permitted all kinds of prophylactic regulation. The big issue was whether truth would be a defense to defamation, and it's not clear what they had in mind. So it's not that I think international law is relevant, but it's that when it comes to means-end scrutiny, we face a real problem in this country, because as a result of funding restrictions that Congress has put on since 1994, firearms violence research in this country has been greatly circumscribed. We don't have a lot of good data. When I first got involved in this issue, I was a lawyer working for Mayor Daley. And I contacted somebody who works on these issues at Johns Hopkins School of Public Health because I wanted to learn. And I was asking him a bunch of questions about the impact of firearms regulation on crime rates. And a lot of these questions he couldn't answer. He started getting really frustrated with me. And he finally said, you got to understand something. What you're trying to do is like trying to make the case that tobacco causes cancer before the Surgeon General's report. Can't be done. You need the Surgeon General's report. And as long as they're not funding firearms research, you're never going to get the Surgeon General's report when it comes to these gun laws. So it's pretty easy, if you don't permit any research, to then say, there's no proof any of these laws work. So that's why, at the policy level, I think it does become important to start looking at international law, because it turns out that in other parts of the world, gun control is awfully effective. Australia is one of the best examples, where they had a lot of firearms in private hands. They then enacted quite restrictive laws, and they were enormously successful. in driving down rates of firearms crime. We have some domestic examples as well, like New York City, which has about the toughest gun control law still extant in the country, and has also been terrifically successful in using that law to drive down rates of firearms crime. So I think that many people on the public health side of this debate like to look to international examples because at least you can find data there. Unfortunately, it is regrettably too difficult to identify adequate sources of data here.
Professor Lund, 3 minutes.
Well, if I'd been asked the question first, I would have just said none and sat down. But since Professor Rosenthal said something, I've got something to respond to. No, the international law has nothing to do with the Second Amendment, or it shouldn't. Maybe someday the Supreme Court will decide to incorporate international law into the U.S. Constitution, but they haven't done it yet, and until they do, it has nothing to do with it. Let me just respond to a couple of points that Professor Rosenthal made. First, the pre-existing right that Justice Scalia was referring to as having been codified in the Second Amendment was not the right in England. So Keller does not tell us we have to look at international law. What the pre-existing right he was referring to was a right that existed in the United States, in the states, primarily in the common law and in the state constitutions. So there is no indication in Heller that we can look at English history and look at the Bill of Rights of 1689 for some hints or evidence about what people might have been thinking the right to arms was in 1791 in the United States, but it did not. Nobody, certainly on the Supreme Court, nobody thinks that the Bill of Rights of 1689 in England was somehow incorporated into the Second Amendment. One comment on the bad tendency test and the early free speech decisions. I think it's true that for a very long time, the United States Supreme Court and a lot of other courts as well did not take the First Amendment as seriously as they should have. It took a very long time for them to start doing that. That doesn't necessarily mean, however, that when the court finally started taking the First Amendment seriously in the 20th century, that it was not following the original meaning of the First Amendment. That's a separate question, whether the First Amendment doctrine of the 20th century is a violation of the original meaning. Just because it was a long time coming doesn't mean that it was that it was not consistent with the original meaning. And certainly some members of the founding generation, James Madison in particular, had a much broader view of what the Free Speech Clause forbade than you would have guessed from the common law that existed at the time the First Amendment was adopted. And Madison was certainly very clear that the Bill of Rights was not simply adopting the law of England in the case of the Second Amendment or any of the other amendments.
Mr. Rosenthal, 2-minute final response.
History is so tricky. This guy Madison was the same guy who originally campaigned for ratification of the Constitution by saying, we didn't need a Bill of Rights. And in his private correspondence, when he, after explaining why he flipped, he said, well, it can't do any harm. We should understand these people the way they understood themselves. Madison was a politician. There was a political movement toward a new constitutional convention. He wanted to head it off, and he thought the best way to head it off was with the new Bill of Rights. I looked pretty hard through Madison's papers to try to find some explanation of what he thought free speech rights were. And the closest I could come was he said, well, it's more than just a rule against prior restraint, but how much more, I don't know. That's all he said. And most people disagreed with him. We forget the Congress, both houses, by healthy majorities, enacted the Sedition Act. And all the judges upheld the Sedition Act. What historians know and law professors are still haven't really figured out is that people in the past don't think the way that we think today. They do things differently in the past. Courts had never upheld individual rights against legislation back in the 1790s. People were thinking of these rights in very primitive terms. And so that's why I think that history gives us such limited, if any, insight. If you wanted to kill somebody in 1791, the best way to do it was with a knife. Guns were hard to load, they were hard to aim, they misfired, they were very inaccurate. Guns posed very limited threats to public safety in 1791. So trying to figure out how guns got regulated in 1791 just gives us terrifically little insight into how they need to be regulated today.
And our third question from Elizabeth Vitale.
Professor Rosenthal, you maintain the right to carry guns in public threatens the ability of urban police officers to identify and investigate threats. Please point out consequences for law enforcement and public security following the Supreme Court decisions in Heller and McDonald.
Well, thus far, all that's really happened is outlier laws have been struck down, like the D.C. and Chicago laws. And if all that's happening is that the outlier laws get struck down, I think Professor Lund and I will agree that the consequences are not going to be significant. We may part company on whether that's a good or bad thing, but we'll probably agree that the consequences of Heller and McDonald won't be significant. If, on the other hand, we wind up with a Second Amendment sufficiently robust that everybody, or at least everybody who hasn't been convicted of a felony, has the right to carry guns in public, then the ability of the police to intervene on the streetscape, for example, New York's strategy of targeting criminogenic hotspots where gang members and drug dealers gather. There's a reason. Street gangs are the only type of criminals who commit crimes in broad daylight. You know, my guess is if we organized an expedition here and we had a narcotics detective leading it, within 20 minutes, he could take us somewhere where we could watch a drug deal in broad daylight. Isn't that amazing? What other kind of criminal commits crimes in broad daylight? There's a reason you don't do it, because ordinarily you think that if you commit a crime in broad daylight, you're going to get turned in. But a criminal street gang that terrorizes its community has impunity from that kind of intervention, because anybody who calls the police is going to have their window shot out the first time and their kid shot the next time. So how did New York address this situation? It identified the statistical hotspots of crime, the open-air drug markets, and it had the police intervene by stop-and-frisk tactics aimed at finding guns and drugs. They didn't wait for somebody to get shot, because by the time somebody gets shot, it's too late. You go to the scene and everybody says, I didn't see anything. But if you can intervene proactively, you can address crime. The New York sin, if it was a sin, is that they were so wildly successful that they probably, at some point in the middle of the last decade, they probably went past the point of diminishing returns. But nobody can argue with the wild success that New York experienced. But if you can't intervene in a high-crime neighborhood until after somebody gets shot, you've already lost the fight. That's what the new policing that emerged in the 1990s learned, that you have to proceed prophylactically. And what I find so striking about that is it's also the lesson of firearms regulation in this country. Because all these laws that I canvassed that somehow emerged, despite or in tandem with the Second Amendment's regulatory power over the course of American history, they were all prophylactic laws. They were all laws, whether it's carrying concealed weapons or disqualifying people who were convicted of crimes or mentally ill from carrying firearms. They were all laws that emerged based on the recognition that by the time somebody gets shot, it's too late. The authorities have to be able to intervene early. So I'm not terrifically concerned. The only thing that happens is the Chicago and DC laws get struck down. I don't think it's going to be a good thing because, again, if handguns are illegal, it becomes riskier to have a handgun, and that raises the price, and that's a good thing. There's a fascinating study by Philip Cook and his colleagues out of Duke about how difficult it is for most young kids in Chicago to join gangs because it's so hard for them to raise the money to buy a gun. That was the effect. So I don't think it's a good thing that these laws got struck down, but I think the effects will be limited. But if we wind up with a regime where the police can't intervene on the streetscape until after somebody's been shot, I think that's going to be a terrifically bad thing, not for the people in this room. You'll all be fine, because as far as I can tell, all of you can afford to live in low-crime areas. But for the people that can't, afford, it's going to be a real problem. And I think that's the real tragedy here. Most people in the middle and upper class can afford to live in neighborhoods where liberal firearms rights probably have net social utility in terms of self-defense, sport, hunting, etc. But the poorest among us can't afford to live in those neighborhoods. That's where firearms violence is concentrated. Those are also the least politically powerful neighborhoods. Mayor Daley, I used to work for Mayor Daley, and he had a line he used to use in high-crime African-American neighborhoods that brought the house down. It may not mean anything to anybody in this room, but they loved it. He used to talk about the NRA and used to say they want to protect their liberty by letting the gangbangers run your neighborhood. Probably doesn't mean much to those of you in this room, but in those neighborhoods, they applauded till they wept, because that was the reality of their life.
Professor Lund, 3 minutes.
Yeah, I've been a little hesitant to get too deeply into the criminology of guns and the empirical studies and so on. Everybody's got studies on their side. My own belief, based on a fair amount of study of the studies and the research, is that gun control laws of the type that have been employed in this country have very little effect on violent crime. Very little effect. It's also true that the liberalization of concealed carry laws in over 40 states has probably had very little effect. You've probably heard the more guns, less crime thesis. There was a big study, the most sophisticated study that's ever been done in the area of gun control, that purported to show that when you liberalize concealed carry and there are more law-abiding citizens carrying guns, crime goes down. There's been a huge debate over the statistics used in this study and so on, but nobody has been able to show that increased crime. Certainly nobody's been able to show that. No serious person suggests it. Similarly, with most of the other laws, the effects seem to be quite small. So you can speculate about what will happen if the courts begin to recognize more robust rights. They're not likely to recognize a lot more rights that are a lot more robust than already exist in over 40 states, where virtually any law-abiding adult can get a license to carry a concealed handgun in public. They're not liable to go much farther than that. And so far, we haven't seen in any of those 40-some states any evidence that that's going to lead to serious problems of increased crime. Now, I do want to respond to this idea that stop and frisk and these kinds of things are the kind of thing that a robust Second Amendment right will stop and therefore lead to more crime in these high crime neighborhoods. The reason you can just as easily say that the reason that the law-abiding people who live in these neighborhoods are at the mercy of the gangbangers is because the law-abiding people are by definition unarmed. They're by definition unarmed. So it doesn't seem that that leaving it to the government to control violent crime in these poor neighborhoods has done a great job, and it certainly deprives specific individuals in those neighborhoods, law-abiding individuals, of the tools that, the tools they need to defend their own lives, and that under the principles on which this country was founded, they have a right to defend their lives. They have a right. And I just don't think that the courts can or should do in the Second Amendment area what they have not done in the First Amendment area, which is say, well, the government might be able to prevent some bad things by suppressing speech. What about the Fourth Amendment, the ban on unreasonable stops and searches and seizures? That lets all kinds of criminals go free. Well, get rid of the Fourth Amendment, the police will have more power, and that is going to necessarily be an improvement. Nobody thinks of that. And why exactly people kind of casually make that assumption in the Second Amendment area, to me, is a bit of a puzzle. Thank you.
Professor Rosenthal, the final 2 minutes.
Well, I think the Fourth Amendment is a good analogy. I tell my criminal procedure students that the reason this course is so hard is that the Fourth Amendment only prohibits unreasonable search and seizure. And that's such a difficult balance between liberty and order. And I think that the Second Amendment, which does contemplate a well-regulated militia, not everybody shooting at each other pell-mell, gives us a similar example. You know, more guns, less crime is a great slogan, and careful analysis often yields to slogans. In fact, the National Research Council convened a commission, and they found that only one intervention actually succeeded in driving down crime in these high-crime areas. It wasn't more guns, less crime, which, by the way, is statewide analysis. It doesn't even try to show the effect of these permits in high-crime neighborhoods, even though crime is a local phenomenon, not a statewide phenomenon. One intervention was effective. Stop and frisk targeted at hot spots, looking for guns and drugs. Why not more guns, less crime? Well, what the data shows, guess who the people are who are carrying firearms at the highest rates in these high-crime areas? It turns out they're gang members and drug dealers. Does that make them safe? No, they also have the highest rates of violent victimization, because when everybody's armed, guess what happens? It's called the drive-by shooting. Those of you that are familiar with firearms should ask yourself, why do a drive-by shooting? It is extremely hard to hit your target from a moving car. It's the worst way to try to shoot somebody. It's also the type of shooting most likely to injure or kill an innocent bystander. Why do it? If you think your target is armed, you obtain tactical surprise and a quick escape through a drive-by shooting. So having everybody carry guns, it may sound seductive to some, but the answer is when rates of carrying are elevated like that, it's not that crime suddenly disappears, it's that everybody's shooting at everybody else. There's no substitute for dealing with the root causes, and the root causes are the violent competition that spurs these rates of carrying guns. The panacea is not to have everybody shooting at everybody else. All the police officers were shooting at Times Square the other day, and we saw what happened to the innocent bystanders. History suggests that prophylactic interventions are more effective than having everybody shoot at everybody else.
We now have time for a few questions from the audience. So if you're interested, we have a couple of microphones down here, and our ushers will bring those to you. If you'd raise your hand, I can have them go toward you. Right here in the middle.
Professor Rosenthal, you explained that gun regulation has quite the history of minority oppression. Are such prejudiced precedents really valid to justify modern regulations?
5 minutes, Professor Rosenthal, if you take that.
Well, I'm not sure if I understand the question, but I'll give it a try. We're not all similarly situated when it comes to the balance between liberty and order. The example I like to give is I like to say if in Montana they repealed all their gun control laws, if it were legal to own bazookas were legal in Montana, actually it would probably be fine, because you've got a very stable, law-abiding population there. And the social benefits of liberal firearms availability probably exceed their costs. It's not coincidental, though, that the costs of firearms crime cluster in disproportionately poor, disproportionately more minority urban areas which also experience disproportionately little political power. So the balance between liberty and order looks different to you, depending on where you sit. I think that's the political problem that the advocates of gun control face. It's not that the NRA is full of a bunch of racists, but it is true that the NRA is full of a bunch of people who see the costs and benefits of gun control differently based on where they are able to live. And people who live in high crime areas see the costs and benefits of gun control differently as well. You can always find somebody in these neighborhoods. You can find an Otis McDonald in Chicago who says the answer is, I want to own a gun. But the interesting thing about that is that the gun control laws in Chicago and D.C., it's not that the Russians invaded and imposed these gun control laws on Otis McDonald. It's that for decades, a clear majority of the people who lived in these majority-minority cities thought that robust regimes of gun control were appropriate because that was the reality of our lives. I used to have, when I worked for Mayor Daley, I used to go to community meetings, and I would have African-American women come up to me from these poor neighborhoods after the meetings and ask me, say, could you get the police to search my son's backpack every day on his way home from school? Because they thought if I could get the police to search the backpack, their child would be safe. Their child wouldn't wind up selling drugs or in a gang. Now, why did they do that? If Professor Lund is right, that's a spectacular misjudgment. In fact, their son ought to be armed, maybe a submachine gun, and whenever a suspicious car starts down the street, just open up because you can never tell who's heading in your direction. But that's not the way that they saw it. They saw it that they needed intervention. Now, that doesn't mean the Second Amendment can be put at naught. No more than the Fourth Amendment can be put at naught. These are difficult issues, balancing liberty and order. The only point I'm trying to make is depending on where you live or where you can afford to live, the balance can look very different to you.
Professor Lund, 3 minutes in response.
Yeah, just very briefly, if I understood the analogy about the woman and her son in the backpack, Professor Rosenthal is suggesting that maybe it would be a good idea to suspend the Fourth Amendment in high crime areas because the police certainly wouldn't have had probable cause to search the guy's backpack every day. The other point I'd like to make is that we had extremely restrictive gun control laws in Washington, D.C., in New York City, and in Chicago for decades, and it doesn't seem that it did much about the crime problem or the gang problem. But what it did do, it prevented honest people from being able to defend themselves against criminals. That's what it did for sure.
Response, Mr. Rosenthal?
Well, the Washington, Chicago, New York examples are interesting because the data from those three cities tell three very different stories. Now, in Chicago and D.C., there actually are studies that suggest that crime rates were reduced because of the firearms laws, but there are studies on both sides of the question. I note there was only one brief submitted to the United States Supreme Court in both the Chicago and D.C. cases by criminologists. And the criminologist brief in both cases argued that the crime rates were lower in those cities. The problem, of course, is that those cities are surrounded by jurisdictions with lax gun control laws, which blunt the efficacy. But New York is quite a different story. New York has been with the same set of laws, New York has been enormously successful in reducing firearms-related crime. Now, why is that? Part of the problem is criminologically, you can't just study the laws on the books, but you have to study it how they were enforced. And because New York adopted the Comstat approach, in which enforcement was targeted at these hotspots of crime, and then was willing to take the political heat for aggressive enforcement at the hotspots. they enjoyed enormous success. Now, we can debate this. Professor Lund and I are never going to persuade each other. But when we have sharp empirical differences like this, I ultimately stand with democracy. I think the democratic process ought to hash these things out. And if restraints are unjustified, people like Otis McDonald can vote with their feet, or they can try to persuade their fellow citizens. Again, that doesn't mean we can put Second Amendment rights at naught. But I do think when we try to balance liberty and order, we can't just start with the presumption that criminals will always find a way around these laws, because if that's the presumption we start with, as I suggested earlier, we could pretty much repeal the whole of the criminal law. Because as long as the crime rate is above zero, you can say criminals will find their way above these laws. But the fact is, economists tell us things work differently, and they do.
Take another question. Let's go back here to the back corner.
Thank you. This question's for Professor Lund. Since we're using the Fourth Amendment as an analogy with the Second, it's been shown that the courts have struggled with interpreting Fourth Amendment with changing technology. And we've had such diverse decisions as Jones and King within 2 terms of each other. For the courts interpreting the Second Amendment, we're also challenged with changes in technology. Obviously, the firearms from 1791 to today are very differently, and with the advent of 3D printing, it may now be possible for people to manufacture their own guns at home. So my question to you is how should the courts approach the changing technology in their application of the Second Amendment?
Well, you're absolutely right that there have been enormous changes in the technology of weaponry since 1791. And the most important change in technology has been the change in the technology of military weapons. It would obviously be insane to say that private citizens have a right to own nuclear weapons. That would just be insane. And there's nothing in the Constitution to suggest that that would be done by the Second Amendment. But it's also the case that in the late 18th century, people had what was then, in effect, a right to own their equivalents of nuclear weapons, things like cannons. There were not laws preventing people from owning cannons, and people did own cannons, primarily rich people that hoped to be a big shot in the militia when one was formed and so on, but they had the right. And the technology of weaponry has changed so dramatically that I think Professor Rosenthal is right. We can't look at these situations and pretend, we're like one of these actors down in Williamsburg. How would he thought about it, how would somebody in the 17th or the late 18th century have said, well, is that constitutional or not? They just didn't think about things like nuclear weapons or aircraft carriers, shoulder Stinger missiles, and so on. And so you have to have a jurisprudence that takes account of the changing technology in the Second Amendment area, just as we do in the Fourth Amendment area and in the First Amendment area. That is absolutely correct. And there are going to be some challenges that would have just been completely beyond the ken of people in the late 18th century. So we can't go back and ask, well, what did they think about it? They didn't think about it. And that's why, and I don't think Professor Rosenthal and I are on that much disagreement about the main point, which is that the Second Amendment, the main point on this issue, which is that the Second Amendment is inevitably in the courts going to have some kind of means-end analysis required. And that means-end analysis is going to have to take into account the nature of the weapons involved. I think it's inevitable, and there's nothing improper about it. And in that sense, I think we agree that reasonable regulation is permitted under the Second Amendment. It should be permitted under the Second Amendment. The disagreements, I think, are largely, between he and I, are largely at the margins about what constitutes reasonable regulations and what kind of legal analysis should be brought to bear in order to determine what regulations are constitutional and which are not.
Professor Rosenthal, 3 minutes in response.
You know, I agree with Professor Lund. I think, you know, debaters tend to emphasize points of difference. I think there's probably more agreement up here, at least at the meta level of how we should go about this analysis than you might suspect from our remarks thus far. But one of the lessons here is how dangerous it is to try to go back in history and take it back to present, because back then they weren't worried about guns as methods to terrorize whole neighborhoods. That wasn't an issue. Cities barely existed. But they were worried about other issues. The same people who crafted the Second Amendment seemed to find completely unobjectionable laws that said freed blacks not only couldn't be in the militia, but couldn't possess arms. Now, for slaves, I guess it's easy for us to understand why slaves weren't permitted to bear arms. But why freed blacks? Very hard for us today to get our minds around it. But wouldn't have been hard for them to get their minds around it, because these people had skin color that made them suspect. Now, all that should tell you something about how perilous it is to try to translate framing era attitudes to the present. I think the furthest we can go is to understand at a pretty high level of generality that the right to bear arms was thought to be consistent with prophylactic regulation. You don't wait till the freed black actually gets his hand on a gun and shoots somebody. You just say he can't own weapons. But beyond that very high level of generality, it's very perilous. And given the difficulties that we have in assembling proof about the effect of any one discrete intervention on the crime rate, at the final analysis, I'm willing to say that unless there is a very severe burden on this right of armed lawful defense, prophylactic regulation generally should be upheld. And thus far, the lower courts seem to be going in that direction.
2 minutes, Professor Lund?
Yeah, I think it might be useful at this point to interject something that I don't think we've talked about explicitly here today, and which is often forgotten or overlooked in discussions of the Second Amendment. At the time the Second Amendment was adopted, it applied only to the federal government, only to the federal government. And one reason that people at the time didn't have any reason to kind of have debates about the scope of the Second Amendment is that the states, in everybody's mind, remained free to adopt whatever gun control regulations they liked. And so if there was a crime problem or change in technology or whatever, the states could handle the problem. So even if the Second Amendment were interpreted in some really absolute sense of saying no gun control laws of any kind, if you'd asked people at the time, it wouldn't have been that shocking or weird, because it only applied to the federal government. And the states were left completely free to adopt, you know, New York City's laws or Washington, D.C.'s laws or whatever they wanted. So the difficulty today when you start trying to deal with this stuff legally is the 14th Amendment. The 14th Amendment has now been held to have applied the Second Amendment to the state and local governments. And we don't have time to talk about the kind of original meaning of the 14th Amendment and all the debates about that, which are quite complex. But the point is that when the court decides that the Second Amendment applies to the state and local governments as well as to the federal government, it, by that very fact, takes this out of the realm of asking what the people in 1791 would have thought about it, because all they thought about was a ban on the federal government infringing on the right to keep and bear arms. And that's, I think, part of the reason why Professor Rosenthal and I end up in much the same place at some very general level of agreeing that some kind of means-end scrutiny is inevitably going to have to be applied by the courts in evaluating the constitutionality of gun control regulations.
In the interest of time,
You know what, can I just add one thing, because
Go 2 minutes for Professor
I so rarely disagree with Professor Lund, at least at the level of generality we've been talking. But hopefully he'll take a friendly amendment here, because the point he just made, nobody thought the Second Amendment applied to the states, is actually not quite right. Because there were a lot of judges in state courts who didn't get the message. I've got these lengthy, boring footnotes in this paper I'm working on, where all kinds of judges thought that the Second Amendment or state law equivalents did apply to state gun control laws in the early 19th century. And kind of an interesting thing happens. The most often litigated issue were laws prohibiting carrying concealed weapons, which almost always got upheld. And if you read the opinions, they basically say, well, because people who carry concealed weapons are suspicious. People who carry firearms openly are honest, law-abiding, good, honest citizens. And so that's why you regulate. Now, that rationale, that distinction doesn't have much resonance today, which is precisely why I think that it doesn't offer us much help. But again, we do have a fairly consistent pattern from the history that when people did try to focus on these rules, even at the state and local level, the idea that some set of prophylactic regulations were permitted, and they, of course, when they upheld these concealed carry laws, they didn't require some PhD criminologist to go out and do a careful study. They hadn't even invented criminologists yet. But they did have a social sense that concealed carry represented something dangerous, something that posed unacceptable risks. And I think that kind of judgment does inform contemporary debate.
I won't accept that as a friendly amendment, but I'll accept it as a friendly supplement, and I'll just respond in the following way. I don't believe there's any evidence that people in 1791 thought that the Bill of Rights was going to apply to the states. Other people later, and sometimes in some cases with some of the state courts fairly soon, within a matter of a couple of decades, started to interpret the Bill of Rights that way for purposes of their own, and that became very common later in the 19th century. So it's a good supplement that a lot of people eventually came to believe that the Bill of Rights applied to the states. But I believe there's no evidence that anyone said any such thing around the time of the ratification of the Bill of Rights.
Now, definitely in interest of time, we will have some time for questions at the reception afterwards, but now I'd like to ask for closing statements from both of the speakers. We started with Professor Lund, so if you would like to begin closing statements, 5 minutes.
I think I've said everything I can usefully say, maybe I'll cede my time, and if Professor Rosenthal says anything new that I disagree with, I'll have a chance to respond, if that's okay.
Fine. Professor Rosenthal.
I'm not going to retread ground either, I guess. I will offer this one thought, which is of all the initiatives that we saw in 2013, in the wake of the Newtown shootings, by far, I think the most important was President Obama's instruction by executive order that the informal prohibitions on funding federal firearms research that had been produced as a result of pressure by the House and Senate Appropriations Committees were to be repealed, and the federal government will now except when there is a statutory prohibition, fund firearms research. And why is that so critical? Because if Professor Lund and I are right, and we do agree on this much, that there has to be some sort of means-end scrutiny, then my end of the argument is under an enormous disadvantage because we don't get to assemble the facts. Professor Lund can say something that's unquestionably true when he says that if we prohibit Otis McDonald from carrying firearms in high-crime neighborhoods in Chicago, he doesn't get to carry a gun in self-defense. It's right. I can't argue with that. But if he then challenges me to show how these laws promote public safety as opposed to letting Otis McDonald open up as soon as he sees something suspicious going on the streetscape, I'm at an enormous disadvantage. Maybe I am a cockeyed optimist, but I believe that policy will ultimately follow the facts. It took us a long time to get a Surgeon General's report, but we finally did. And it took 2 or 3 more decades after that, but tobacco regulation ultimately wound up being driven by the facts. I suspect that some people associated with the NRA are concerned about exactly that, that if we wind up with the facts, the tobacco analogy is going to eventually drive the debate. And so the gun control side of this debate is under an enormous disadvantage when we can't get the facts. So I embrace means-end scrutiny. And among the reasons I embrace means-end scrutiny is I took an oath when they swore me into the bar to uphold the Constitution, all of the Constitution, including the Second Amendment. We can't put the Second Amendment at naught, but we can't put the preamble at naught either. It's in there too. And it contemplates a well-regulated militia, and we're never going to get to the right balance between liberty and order if we don't have vigorous and unfettered research into the impact of these challenge laws. I don't know why, but there's something about gun control that seems to be the enemy of rational debate. I get these questions all the time. I got them from the political scientists a couple weeks ago at the annual convention. Well, why should we have gun control laws when they only affect criminals? Of course, nobody asks those kinds of questions about any other prohibition in the criminal law. I think the reason that people focus on this is because the Second Amendment is different. There is a right to keep and bear arms, and that's why I try to make the case that the preamble also tells us that there's regulatory authority. We need to balance the two, and that process can't be done with integrity unless we have the facts. And it's my hope that in the coming decades, if nothing else, the political process will operate sufficiently well to allow us to understand the facts. Thank you.
Correct one small misimpression. For several years, there have been appropriations riders preventing certain agencies in the government, primarily the Centers for Disease Control, from advocating gun control measures. It may be that they've informally taken that to mean that they can't do any gun control research. I don't know. But even if they did, or even if the federal government, even if Congress forbade the federal government from conducting research on gun control, that would not be the end of research. There's been lots of research done by lots of people who are not the federal government for many decades. They can continue doing it. It's not the case that research doesn't get done unless the federal government does it itself. And so I think that's just a bit of a red herring. There's a tremendous amount of research. The problem with the research is that so much of it is ultimately indeterminate in its conclusions by any honest reading.
Well, ladies and gentlemen, that concludes our forum. We'd like to take a moment to thank our contributors before we leave. Please hold your applause until the end. Join me in extending a special thanks to the Office of the President and Provost, the Office of Government and Community Relations, the School of Law, the Department of Political Science, the Center for Policy Studies, the panelists, and the 2013 Constitution Day Student Committee, and the advisors William Dahl, Jonathan Enton, Andrew Lucker, and Laura Tartikoff. At this time, you're all invited to proceed upstairs to a reception in the Blackacre Lounge. The speakers will join us upstairs to answer any questions that remain as we continue to celebrate the 226th anniversary of our founding charter. Thank you very much for coming.